Picture that exact moment an inventor sits down to formally file a non-provisional application. You're carrying the weight of years of development and research, only to suddenly realize a stark truth. The specification you are about to submit has to survive strict legal scrutiny under 35 U.S.C. Section 112A, rather than just describing the invention in plain, everyday terms.
This precise legal threshold is the silent point of failure where countless applications ultimately sink. And what is critical to understand from our experience inside the USPTO is that these filings don't fail because the underlying invention isn't real or valuable. They fail because the written description, the enablement, or the best mode requirements simply wasn't fully satisfied on the page at the very time of filing.
By the end of this explainer, you will know exactly what your specification and claims actually have to do to hold up under examination.
Section 1. Surviving 35 U.S.C. Section 112A. Deconstructing the three legal pillars.
So, what is the real difference between written description, enablement, and best mode? Section 112A actually sets three completely separate legal standards. First, written description demands proof, based strictly on your filed text, that the inventor actually possessed the full scope of the claimed invention at the time of filing. Second, enablement requires proof that a hypothetical person of ordinary skill in the art, what we often call a PSITA, could build and use that invention without resorting to undue experimentation. That means if you want broad claims, you have to provide broadly enabling technical details. Finally, best mode mandates that the inventor discloses their actual preferred way of practicing the invention rather than deliberately concealing it behind a lesser version. And the crucial point here is that examiners evaluate these standards strictly through the lens of that person of ordinary skill in the art, rather than a layperson or even a leading industry expert.
Now, can failing just one of these sink the whole application? Yes. The reality of patent prosecution is completely unforgiving here. Failing any single one of these requirements is enough to sink the entire application, even if the other two are perfectly satisfied.
This brilliantly illustrates a long-debated point of law that was ultimately settled by the Federal Circuit's en-banc ruling in Ariad Pharmaceuticals v. Eli Lilly. The court made it unequivocally clear that written description and enablement are two totally distinct legal requirements, not merely one obligation described in two different ways. From our examiner side perspective, this means the USPTO will issue them as separate rejections, and you have to deploy entirely different response strategies for each one. Section 2. Filing fees and requirements, base costs, and hidden surcharges. So how much does it actually cost to file a non-provisional application right now, including those fees people tend to forget about? Well, for a large entity, the base electronic filing fee is exactly $1,920. Breaking down that base total by entity size, small entities receive a 60% discount, bringing their base fee down to $768. Micro entities receive an 80% discount, bringing their fee down to $384. Now, this base payment covers up to 3 independent claims and a maximum of 20 total claims in your application. But there is a hidden surcharge many applicants overlook. Under a technical formatting rule effective since January 17, 2024, filing without the required DOCX format adds a penalty surcharge. That surcharge is $430 for large entities, $172 for small entities, and $86 for micro entities. If you want the full fee breakdown by entity size, including what triggers the extra claim charges, that's laid out in the article linked in the first comment below. Section 3. Provisional Conversion Timelines, the strict 12-month rule.
We often get asked, what happens if I already filed a provisional and I miss the 12-month deadline to convert it? The answer is a stark, unvarnished fact of patent procedure. A provisional application converts to a non-provisional within 12 months of its filing date, and that deadline absolutely cannot be extended once it passes.
So you have to weigh your strategic options carefully. Should you file a non-provisional directly or file a provisional first? Filing directly is often the right move if your invention is fully developed and you want to enter the examination queue immediately. On the other hand, a provisional first approach is incredibly useful to establish a foundational filing date while your ongoing development, testing, and claim refinement continue over that 12-month window. However, if you choose the provisional route, you must remember a vital rule. In order to successfully claim the provisional's earlier priority date, every single element in your non-provisional claims must have been disclosed in that original provisional application with full Section 112A quality. If it wasn't explicitly supported back then, you simply do not get to keep that earlier date for the newly added material.
Section 4. Strategic claim drafting, the ultimate battleground.
So, exactly how many claims can you include before extra fees kick in? As we mentioned, your base fee covers 3 independent claims and 20 total claims. Exceeding 3 independent claims triggers a surcharge of $600 per extra claim for a large entity, $240 for a small entity, and $120 for a micro entity. If your total claims exceed 20, the surcharge is $200 per claim for a large entity, $80 for a small entity, and $40 for a micro entity. This brings us to a pressing viewer question that touches directly on our experience inside the USPTO. Why do examiners scrutinize independent claims far more heavily than dependent ones?
The answer really comes down to how an examiner approaches the file wrapper. Examiners read independent claims first. Because independent claims define the absolute outer boundary of your patent protection, examiners evaluate their validity against the prior art before they look at anything else in the claim set.
Which leads us to the single biggest takeaway from our firm's examiner side perspective. If an independent claim is drafted too broadly and reads on existing prior art, a well-drafted, highly specific dependent claim underneath it will not save that independent claim from rejection. The foundation must be fundamentally sound on its own.
If you're preparing to file and want your specification and claims reviewed before submission, the link to schedule a consultation with a former USPTO examiner is in the first comment.
Subscribe for more guidance on USPTO procedure without having to search for it each time. Protect your hard work by getting the specification right on day one. Because you have to ask yourself, if an examiner opened your application right now, would your independent claims survive their very first pass?